I know from some statistics from the Ministry of Justice that the pretrial detainees are something like 32.6% of the total prison population.
So if someone has not got the nationality, the Greek nationality, in the judge's mind, I think, and the mentality of the judicial system, he's actually a risk to flee the country. The second factor, of course, is the accusation. If the accusation is a severe accusation, a grave accusation, we know that most cases are likely to have the measure of pretrial detention.
A big category of defendants, for example, people apprehended during demonstrations. In these cases, I was never allowed to see my client unless officially they are arrested, and then the police allows a lawyer to communicate with the client.
I'm almost never there for the police interrogation. So when I go there, I am trying to find the accused.
Usually family members call us, call the lawyer, and inform the lawyer that, for example, my family member is in the police station. We don't know why, we don't know when the family member went to the police station, and we don't know how long they're going to stay there. So then we start searching for our client.
And I have no space to speak with him or her. The accused people, they are behind glasses and the telephones are broken. So I have to shout.
If you want to actually speak to your client and he cannot speak Greek or English, because, okay, we all know English, usually, we have to have, for example, a cellmate translate. So the quality of translation isn't that great, obviously. And also, they don't actually ever get their rights in their language of origin, which is a huge problem, or the accusation. So we don't have anything online, we cannot have access to the case file, and we have to wait in order to go before a judge, ask for the case file.
You have to photocopy it by yourself on the expenses of the defendant or the legal aid lawyer.
And if it's a huge case file, it might take a day to be copied in order for us to actually get access after 2 days.
First thing, I always have well-based written submissions to the investigative judge arguing against pretrial detention. I mean, you have to do that, to say the grounds on which they cannot be released, to argue on restrictive conditions, to ask for them, to explain why, to say, for example, that they have health problems, that they have a family, that they have a permanent address, that there are alternatives to detention, that it's the ultimum refugium, that it's the last resort.
Also, it's important for each detainee, each accused, to understand the procedure, the criminal procedure, from the beginning till the day of the interrogation before a judge, in order for them to be much calmer, to be able to clarify certain things on the case, and to help you, at the end of the day, know what exactly you're looking for in each case.
It is crucial to come in contact with the detainee, specifically in as much earlier process of the proceedings as possible. It is crucial to make written pleadings about violation that occur in each stage so that you can prove the lack of safeguards in the proceedings. And it is crucial to know different kinds of procedures that may be applicable to this person. If the person is a third country national, non-EU national, for example, in many cases these persons are asylum seekers. The lawyers that represent these persons do not know that there are parallel asylum procedures. So the person is put in pretrial detention and the authorities in between them do not communicate. So the person does not appear in the asylum service for the parallel asylum application, and the international application is stopped, and the person then faces deportation.